Yep.
For this case, what is she saying? She's saying that you ordered me to show up because you want to find the mole. Fine. Now, suppose you find the mole. I say it's me. Do I get to determine how long you put me in jail for?
So speaking of Lil Woody, we were just talking about his whole situation that went on and everything that happened with the secret meeting, right? And the reason we're talking about this breaking news is because his former attorney, Kayla Bumpkiss, is actually filing not only a motion to quash the order to show up, excuse me, not only is she filing a motion to quash, but she's actually filing a motion to recuse, taking more shots at Judge Glanville, trying to get him off of this case. Now, we mentioned in a past video that coming up on June 25th, there's going to be a hearing, and it's all going to be covering the situation that went on with the secret meeting. What happened was Kayla was representing Lil Woody. She was only representing him for one day because Lil Woody's attorney was out of town. He had some non-refundable tickets and he was trying to get to Hawaii. He said, "Hey, Judge, I can't be there. I got to go to Hawaii. We've got Kayla. She's going to take care of everything." Kayla shows up, and then y'all may have seen that clip of Lil Woody actually firing her while he's on the stand. He said she 5, and then he got Kayla up out of there. So what happened prior to her getting fired, though, is that Kayla was actually a part of this secret meeting that took place between Judge Glanville, the prosecution, and Lil Woody. So it's looking like Judge Glanville, the reason he wanted to know the name is because he had a feeling that Kayla was the one that was the mole. And as we look at other documents and this document as well, we're going to see that it was clear that Judge Glanville knew that Kayla was the mole, and he wanted to know her name so he could either talk to her, get her up out of there, whatever he needed to do. All right, so we're going to get into it and read what's going on here. We're also going to have some help from the lead attorney. He covered this over on his channel. I'm going to play a clip from his video so y'all can see and hear from a lawyer exactly what some of these terms in this motion to quash actually means. All right, so we see this is the state of Georgia versus Khalif Adams. All right, and this is a motion to quash, order to show cause, and motion to recuse this court. Comes now attorney Kayla Bumpkiss. This is Woody's former attorney, through undersigned counsel, and files this motion to quash the court's order to show cause, filed June 11th, 2024. All right, so this was filed within a little over a week ago. Or in the alternative, moves this court to transfer this action to another judge or recuse itself as required by law. Okay, so she doesn't want Judge Glanville to rule on this indictment, right? Excuse me. I apologize, y'all. Give me 1 second. Goodness. So what is happening is Kayla is being held in contempt of court because it's believed that she leaked the information from the secret meeting, and the judge is saying that Kayla wasn't allowed to do that because what happened in the chambers is supposed to stay in the chambers, right? Legally. Well, we're going to find out that might not be the case in this specific situation. So let's see what she says. Recitation of the facts. On Friday, June 7th, during the trial, I'm struggling, y'all. Bear with me. All right, here we go. All right, we're gonna get into it. We should be good now. Let me get a little bit more water. Here we go. Recitation of the facts. On Friday, June 7th, during the trial, the state immunized. That means they gave immunity to Lil Woody and called him as a witness. Lil Woody refused to testify, which we saw in the last clip. The court placed Lil Woody in custody over the weekend for his refusal and adjourned until Monday. At this point, Lil Woody was still sworn as a witness and had not been dismissed. On Monday, June 10th at 8:30 a.m., Lil Woody and his lawyer, Caleb Bumpkus, were escorted to the court's chambers. Okay, so here we have another verification that this meeting actually took place. And as y'all know, Judge Glanville never actually denied it in court as well. He just wanted to know. He said, hey, Brian, who told you about the secret meeting? All right, so they were escorted to this court's chambers and conducted an ex parte meeting regarding whether Lil Woody would testify. Oh man, not looking good for Judge Glanville. Those present for the substantive portion of this ex parte meeting were Judge Glanville, they're naming names, Lil Woody, Attorney Bumpkus, Assistant District Attorney Adrian Love, and Simone Hilton, members of the court's security staff and deputies, 2 investigators from the district attorney's office, and a court reporter. Good Lord, they had everybody there except for the defense. Man. So with the court reporter being there, we talked about getting the transcripts. Judge Glanville said he is going to make the transcripts of this meeting available to the defense. Now, whether all the information from the transcript from this meeting is going to be there, we don't know. We don't know if certain information is going to be redacted, but at this point, Judge Glanville, with him feeling the heat, he might as well just give them everything that they need, right? In chambers, this court asked Copeland whether he was prepared to testify. Lil Woody announced that he planned to again invoke his Fifth Amendment right. Oh man, his Fifth Amendment privilege on the stand. So they knew that he was going to do it again because he really didn't want to testify. Y'all have to let me know, is this points towards Lil Woody not wanting to testify, even though, he snitched in the past? We'll see. A conversation among the parties ensued regarding Lil Woody's understanding of immunity. How Lil Woody thought he may testify if he did not invoke the Fifth Amendment and certain facts of the case. So this is when we got more information from the other motion to recuse was filed. This is when the judge said, hey, or the assistant district attorney Hilton was like, listen, you can lie on the stand. If you want to lie on the stand, it's fine. We're not going to hold that against you. But the only thing you're not allowed to say is you can't say that you killed Big Nut, because then that's going to ruin our whole case, right? So that's what they're talking about here. Once Lil Woody learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Lil Woody decided that he would testify. Now, this is when Judge Glanville threatened him and he said, hey, Lil Woody, listen, I know you don't want to testify, and that's fine. You have a right to not want to testify. But if you don't testify, I'm going to hold you in jail until this case is done. And we're not even halfway through all the witnesses. We're not even halfway through this case. You could be there for a year, 2 years, 3 years. Who knows? Who knows what's going to happen? So if you don't want to testify, that's fine. But just know what's going to happen if you don't. Lil Woody added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. Excuse me. This ex parte meeting was not placed under seal. This is important because the reason Kayla is being held in contempt is because if she were to reveal anything that happened in this meeting, if it were under seal, then she would be in trouble. She'd have to do time, etc., etc. But she's saying this meeting, the judge never said that we couldn't reveal anything that happened in this meeting. Well, it's just like if you were to walk into the judge's chambers and you were to say, hey, judge, I'm about to get some lunch. You want some lunch? He said, yeah, that's fine. I want lunch. And the court report is there, takes it down. Y'all talking about lunch and you talk about it later. That meeting was not placed under seal, right? You're just asking the judge about lunch. So just because you walk into the chambers and have a conversation, that doesn't mean that everything is placed under seal. All right. And the lead attorney is going to talk about this in a minute. There was no protective order that directed that disclosure of these ex parte communications was prohibited. No attorney-client privilege existed clearly, as 2 prosecutors, investigators, a judge, a court reporter, and various court staff were also all present. That makes sense too. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or in any way privileged information. Okay. And she has a note here that says, if there was any privilege, such as attorney-client or work product, the privilege would be destroyed with all other parties present, particularly the court reporter. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys off the record in the case, who were also fellow officers of the court. So she had every right to share this. This whole thing is a mess, man. Later that same day, defense counsel attorney Brian Steele addressed this court to make a record of his due process concerns regarding the ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to the defense under Giglio and Brady. Not sure about that case. We can look up more information on that at a later date. During attorney Steele's attempt to put his due process concerns on the record, this court began to focus on the identity of the source who leaked the meeting to the defense counsel. Judge Glanville got upset, said, Brian, you're not supposed to know about this meeting. Who told you about this meeting? Because the judge is alleging that the meeting was, as previously stated, how did they put it? Under seal. Okay, but we're going to find out that it wasn't. And Kayla's saying that it wasn't as well. All right, so it was leaked. The court ordered attorney Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Attorney Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action, the attorney could purge himself of contempt if he provided the information to the judge. So we're going to get into the difference between civil and criminal contempt here in a second. But what was, let's see, a brief hearing followed, and what initially appeared to be a classic civil contempt action became a criminal contempt action, meaning that, well, I'm going to let the lead attorney explain it because he explains it better, but that basically means that Brian Steele was 100% going to jail, and he didn't have a choice of how long he was going to be in jail. So the judge removed all rights from him to say, okay, judge, fine, I'll tell you, let me out. The judge said, nope, you're doing 20 days and that's it. Like, get out of my face. The court found attorney Steele in direct criminal contempt. The court sentenced attorney Steele to the maximum time allowed, which was 20 days to serve in the Fulton County Jail. All right. Attorney Steele has since received an appeal bond, and his contempt proceeding was stayed by the Georgia Supreme Court. So Brian Steele's on top of the world right now. On June 11th, the court entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th, 2024. Specifically, Lil Woody, his attorney, Miss Bumpkiss, and all representatives of the state and court security personnel that were in attendance to show cause why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to the members of the defense counsel. No specific names were included in the order other than Lil Woody and Miss Bumpkiss. So it's looking like Judge Glanville, he really wanted to verify what he already knew, or what he thought he knew. He wanted to verify that Miss Bumpkiss, Kayla, was the one who told Brian Steele about the meeting. She probably walks out there like, hey, yeah, I was just with the judge talking about this. And Brian said, yo, hold on a second. Y'all had a meeting? She's like, yeah, we had a meeting. This is what we talked about. He told Woody he's going to stay in jail. And so we're all good now. So yeah, Judge Glanville was not happy about this. And this is going to be a bad look in the case overall. Is it going to change anything? I don't know. We'll still have to see. Here's the argument. The court seeks to hold in contempt the person that leaked the ex parte meeting to the defense counsel, meaning Kayla. Thus, the contempt hearing will be about who informed defense counsel, whether to find that person guilty of criminal contempt, and if it's found, the appropriate punishment. Ooh wee. So basically, Kayla, she wants to She doesn't want the judge to decide how long she's going to be in jail for. This hearing is coming up on the 25th. We'll cover it if this hearing takes place and when it takes place. But yeah, Kayla doesn't want the judge to decide how long she's going to sit in jail for. The procedures that a trial court must follow to hold a person in contempt depends upon whether the acts alleged to constitute the contempt were committed in court or committed out of court. That's interesting. It says the procedures that a trial court must follow to hold a person in contempt depends upon whether the acts alleged to constitute the contempt were committed in court or committed out of court. Interesting. All right. It says an alleged communication act may only be said to have occurred in the presence of the court, warranting summary contempt proceedings, and the act was committed in open court. On the other hand, where the alleged communication acts are committed outside of the court's presence, the considerations justifying expedited procedures do not pertain. Thus, summary adjudication, I believe is how you say it, of indirect contempts is prohibited, and due process requires that a person who is tried for indirect criminal contempt is entitled to more normal adversary procedures. Among those things, he or she must be advised of charges, have a reasonable opportunity to respond to them, and be permitted the assistance of counsel and the right to call a witness. Okay, so basically you have more, depending on the type of contempt, you may have certain rights, is basically what this is saying. All right. So I'm going to scroll down a little bit here, and it says, it explains the disclosing information from the ex parte conversation to the members of the defense counsel occurred not in open court or in chambers, but at the time and location that the defense counsel were notified of the ex parte meeting. So they're basically saying the contempt happened when she told Brian Steele about the meeting. Okay, it didn't happen in court. It didn't happen in the judge's chambers. The court wasn't present at all. They were just out having a conversation and it came up. Further, direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. All right, so if you're yelling, you're getting out of hand in the courtroom or in the presence of a judge, that sounds more like a direct contempt. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. Let's see. Forms of contempt are further divided into criminal and civil. Okay, this is a pretty important section of this, so y'all check this out. Based on the nature of the punishment imposed, civil contempt is a conditional punishment intended to coerce the contemptor to comply with the court order. All right, so I guess, and again, y'all correct me about this in the chat. I know we have several lawyers that watch the channel, so y'all please let me know if this is right. But it seems to me, I guess, if the civil contempt would be if you're in court and say you're yelling or you're getting upset or frustrated and you're interrupting the judge. The judge can hold you in contempt, let you cool down, and then you say, all right, I'm good now, judge. You can let me out. That's the first thing that comes to my mind. Y'all have to let me know if that's correct. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and punish disobedience of its orders. All right. The contempt alleged by the court of disclosing information from ex parte conversations to members of the defense counsel could only be criminal contempt. Nothing can be done to purge or undo that alleged contemptuous act, and any punishment would amount to criminal contempt. All right, so now here we're gonna go over to the lead attorney's channel. Again, let me give a round of applause to the lead attorney. He's done an amazing job covering this case along with his co-host AV to the 7th power. I'll leave a link in the description to this video and to both of their channels as well. All right, but he's gonna explain a little bit further what all of this mean and kind of give some clarity to the difference between civil and criminal contempt. Check it out.
Nothing can be done to purge or undo the alleged contemptuous act, and any punishment would amount to a criminal contempt. Now, what is she saying right here? You got the criminal contempt, and then you got the civil contempt. Civil contempt is what you guys run into with child support. That's child support. So many men, hundreds of thousands of men in jail on child support. Why? Because you owe $3,000, you owe $5,000, or alimony. We need to check on that damn Nathan Wade case. Nathan Wade does not want to pay his wife $4,000, and they filed a contempt. What is that? That's civil contempt. What are they saying? You, Nathan Wade, y'all know Nathan Wade, who was dicking down Fannie Willis for $750,000. Shout out to Fannie Willis. Fannie Willis was like, listen, I know I'm 53 years old, and I know, man, I'm not in my prime anymore, but I know how to get some dick. All right, I'll pay one of these black men around here $750,000. Y'all women can go be celibate if you want to. I'm gonna be a new celibate woman. Fine. Fannie was like, hell no, I need somebody to bend me over this damn fax machine.
Oh my God.
Fannie's gonna get it. All right. Fannie's like, I will let these taxpayers pay $750,000, but I'm gonna get me some. Y'all women can be celibate if you want. Anyways, Fannie Willis was having sex over the fax machine with Nathan Wade. Nathan Wade is married. All right, we ain't gonna talk about all that. Nathan Wade's got a whole wife, and Nathan was supposed to pay her $4,000. He did, and he said, "Listen, baby, I ain't got it." The wife was like, "You just got $750,000." Nathan said, "What the hell did I tell you? I ain't got it." Right? You got $750,000. Okay, let me be more specific. Since you can't hear earwax, I don't have $4,000 for you. Don't look at my $750,000. I don't have $4,000 for you. Nathan's wife is represented by Andrea. So Andrea filed a civil contempt. What does Andrea want? Now, she wants a lot of stuff, but she wants the $4,000. What does she anticipate the judge is going to do? The judge is going to say, okay, wait, okay, Nathan, like, here's the thing. You need to pay her $4,000.
And Andrea's his wife.
So, did you bring a check to court? I didn't bring a check. You didn't bring a check? I didn't bring a check. Okay. But you owe her $4,000. I do owe her $4,000. But you didn't bring a check to court? Did you bring cash? I didn't bring cash. Okay. So you don't have any funds to pay her right now. I don't have any funds, Judge. Okay. All right, here's what I'm gonna do. Bailiffs, take Mr. Wade into custody. Wait, Judge, how long I gotta be in custody? You decide. If you pay this lady $4,000 right now, you don't go into the back, you're good, you walk out of here. If you wanna pay her tonight, that's fine. We'll let you out as soon as the $4,000 hits her hands. If you wanna pay her tomorrow, but here's the thing, Nathan. If you wanna pay her a month from now, then you sit in jail a month. If you want to pay her in 3 months, fine. She'll get paid in for 3 months. You will be here in jail for 3 months straight. You get the keys. It's not like this if you commit a rape. It's not like this if you commit a murder. It's not like this if you commit aggravated assault. You don't get to decide how long you stay in jail.
And that's what he was offering to Brian Steele initially. And you got, it's frustrating, and I'm sure it's frustrating for Brian Steele because this Judge Glanville has been so inconsistent, and he slipped up. He said things that he didn't mean. He mentioned criminal contempt and he mentioned civil contempt, and you can see how, especially with all of this having so much weight, that it could be frustrating to him because they don't know what the judge is talking about, because there's a big difference between the civil and the criminal contempt.
Assault. You don't get to decide how long you stay in jail. With civil contempt, it's interesting. You get to decide how long you stay. I will go to prison for 30 seconds. I don't give a damn. If you want to put me, fine, I'll go. Shit, I'll go. Yeah, I was a felon. All right? I was in prison for 30 seconds. I'm a man. All right. Now, don't sentence me to 17 years, because then you're not letting me decide. You're telling me the term of imprisonment. I don't want that. I want to be the one. You can send me to ADX. You can send me to the hardest prison that you want. If I can stay there for half a second, I'll go anywhere. So that's what Nathan Wade is up against, the guy that was dicking down Fannie. He gets to decide for $4,000 how long he stays in there. Yep. For this case, what is she saying? She's saying that you ordered me to show up because you want to find the mole. Fine. Now, suppose you find the mole. I say it's me. Do I get to determine how long you put me in jail for? If I get to determine, it's civil. If I do not get to determine, it's criminal. Does anybody remember Brian Steele?
Yeah, here we go.
The judge told Brian Steele that he had to be in jail for 20 days. Was there any way, guys, listen, was there any way for Brian Steele to lessen that amount to 10 days? Was there a way for him to lessen it to 5 days? No, nope. It was a term of incarceration. It was fixed. So Brian's is different. Brian doesn't have the keys to his own incarceration. The judge says,
which I also wonder if that's the main reason that the Supreme Court actually, he was able to appeal that, because he wasn't given the opportunity. He wasn't given the opportunity to decide what he was going to do. So it's kind of a strange situation here.
Brian doesn't have the keys to his own incarceration. The judge says 20 days, it has to be 20 days on the dot. So Brian's is direct. All right, so guys, for you, question. Is Kayla, Miss Bumpus, is her incarceration, because that's what she's looking at.
It's crazy.
Is it going to be in her hands, or is it going to be in the judge's hands? Can she go to jail for 30 seconds? Or is the judge going to try to do her like he did
Brian,
and then give her 20 days?
Mm-hmm.
Yeah, y'all let me know what you think in the comments. I think he's going to lock her up. He's going to give her 30 days or something. And this obviously is what she's arguing here, which it's just crazy again that she even has to do this, because Judge Glanville has so much power in this situation, which is why they're going to have the hearing coming up on the 25th, because I mean, she's just scared. She doesn't want to go to jail. It's just not a great look. And who wants to be in jail anyway?
That's the bad kind. The bad kind is when you do not have the keys to your incarceration.
And is she going to have the same connections to get it through the system and get the Supreme Court to overturn it? Probably not.
Exactly.
So this is what she's saying right here, guys. She's saying, listen, this is what civil contempt means. This is what criminal contempt means. So here's the thing. She says the contempt alleged by this court, Judge Glanville alleging this contempt, could only be criminal, because there's nothing I can do to purge or lessen the contemptuous act. And any punishment would amount to criminal contempt. She's saying that I can't pay $4,000 and walk right out. Brian Steele couldn't pay. Well, that's where the judge fucked it up a little bit, because the judge wanted him to, well, listen now, the judge called it criminal, but this is where the judge got confused. So y'all are seeing the chief judge get confused, because initially the judge wanted to lock Brian Steele up until what? Until he gave a name.
Mm-hmm.
So the judge said, Brian, ¿por qué todo esto? Why are you making a show? Just tell me who the name is, and you don't even go to jail. Tell me now, you don't go to jail. And Brian wouldn't tell. Fine, listen, Brian. And the judge said this specifically. Once you get back there, if you tell me the name tonight, you get released tonight.
Yeah, but then he switched up.
In that situation, the judge was trying to give him the keys. The judge was like, listen, call me on my phone. You tell one of the workers down there at the jail, have them call me on my phone. I will get you out tonight. You don't have to do 10 days, 20 days. You don't have to do any of that shit. Just tell me who the name is. Once it became clear that Brian would never tell, and the judge on the record said it was criminal, fine. The judge was locked in, and he could no longer force Brian to tell the name. He could no longer give Brian the keys to the court. So it went from civil to criminal. And when it was criminal, it's a fixed amount of time. The judge says 20 days, don't have anybody call me to tell me shit. There's no way it's going to be lessened. 20 days on the nose. That's what you're going to do.
Wow. All right, y'all give it up to the lead attorney. Shout out to him for doing a great job. Amazing job covering this case. Make sure you go check him out. Go check out his YouTube channel. Again, I'll have it linked below. I'll drop it in the chat and in the description for y'all, so you can go show him some love. Check out this video and the live stream that they just did. And I'll be linking AV to the Seventh Powers YouTube channel below as well. There's a good bit more to get into here, because she goes through a lot of what happened. But again, it's pretty much just going into detail of everything that happened in the secret meeting, why she's filing this, because she doesn't want to have to not be able to decide how long she spends in jail, what type of fine she has to pay, what she has to do. So we're going to hear more about this coming up on the 25th. Hopefully Kayla doesn't have to do any time in jail, because honestly, looking at this just from the beginning, it doesn't look like she did anything wrong. The judge didn't say that you're not allowed to share any of the information in this meeting. So I don't see how she's being held, how she's even being held in contempt. So y'all have to let me know what you think. Maybe she has the connection to the Supreme Court and she won't have to do any time at all. We'll see what happens.